The reason you're here is I look at what you say in your reply to Webby's claim, and part of your reply is that you felt during the time you were working for Webby two things. Firstly, that he hadn't properly calculated what you were owed, and also that you were entitled to a portion of that money, not just for wages, but for sundries, for other things during the course of the contract, and he didn't treat you with proper professional regard. And were this an ordinary case where you hadn't taken that money and treated it to yourself, what would have happened if this were a straightforward civil dispute is you would say to me, Judge Rinder, I'm entitled to this amount for wages, this amount for sundries, this amount for the days that I worked and I spent money on transport, that sort of thing, right?
Right.
Have you actually come to a value, an assessment of how much of that £4,000 you might be entitled to?
I would say £600, no more than that.
Well, I want to be clear about it. If this were a straightforward civil case, based on my assessment of the evidence, that's something I would have probably awarded you.
OK.
Do you understand?
Yeah.
It's not that I don't take that into consideration. I have to look at the facts of the circumstances and do justice.
OK.
Webby, you left Che responsible to complete a contract because you were satisfied that he was a decent man, one that could finish the work and one that would be honest. Instead, when you asked him to take custody of £4,000 you were owed, instead of giving it to you, as he should have done, he took it for himself. In the ordinary course of things, that would be theft. It would be a criminal offence. In the circumstances here, based upon what he tells me, and as I now understand the case, in part, he felt he was entitled to some of it. In respect of the rest of it, he took it and used it purely for personal reasons, which he now admits. It's rather too late. When you came back, instead of calling the police, you came to an arrangement for reasons which are best left to you to explain, where you said, fine, I'll accept your £250, but you still owe £3,750. And you came up with an agreement and a loan arrangement, which I'm satisfied he understood and signed, £3,750. In reply, Che says, well, what you have to do is look at all of the days I worked and take some of that off because I'm entitled to my wages. Normally, I would have considered that. You are entitled to some wages. But because you took it in circumstances which I find border on dishonest, and because you're unable to provide me with any meaningful evidence of how much you actually would have been entitled to, I can't come to a confident determination, and therefore can't award you anything. Therefore, the award of this court has to be to you, Webby, for £3,750. That clears the decks. Moving forward, carry on working. And I feel fairly sure that he'll have some clients moving forward. Webby, maybe you'll even hire him. Who knows? That's the award of this court, £3,750.
Webby was awarded his full claim of £3,750.